Hello, everyone, and welcome to this Federalist Society virtual event. My name is Edith Harold, and I'm an Assistant Director of Practice Groups with the Federalist Society. Today, we're excited to host this FedSec forum called The Future of Securities Self-Regulation After Alpine. Speaking on the panel today, we have Brian Barnes and Hardy Calcott, and moderating the discussion, we have Joanne Madero, formerly a BlackRock Managing Director. If you'd like to learn more about today's moderator or speakers, their full bios can be viewed on our website, fedsoc.org. Throughout the program, we may turn to the audience for questions. If you have a question, please enter it into the Q&A function at the bottom of your Zoom window, and we will do our best to answer as many as we can. Finally, I'll note that, as always, all expressions of opinion today are those of our guest speakers and not the Federalist Society. With that, Joanne, thank you for joining us today, and I'll hand things over to you.
Great, and welcome. Thank you, everyone, for attending. This is a very interesting case. On Friday, November 22nd, the DC Circuit issued a decision in Alpine Securities versus FINRA, which is a closely watched case involving the non-delegation doctrine. And I have here two speakers. Brian Barnes, who's a partner at Cooper & Cook. He's an experienced litigator at both trial and appellate level, including constitutional challenges and the lawfulness of agency actions. He clerked for Justice Alito and Judge Griffith of the DC Circuit. He's a graduate of Yale Law School and Yale undergrad. He represents Alpine in its various appeals from the FINRA actions. Hardy Calcott is a partner at Sidley, and he practices securities market and regulation issues for broker-dealers, investment advisors, and others in financial services, including securities defense issues before the SEC, the Department of Justice, and FINRA. Hardy brings with him an experience both as in-house counsel at Schwab and also at the SEC. So he's seen all sides of SRO actions. He's a graduate of Stanford Law School and Yale undergrad. Brian's going to go first, and he's going to explain to us the status of the case and what the issues are involved. And then Hardy is going to discuss the implications for self-regulation in the securities industry and perhaps wider implications more generally. Over to you, Brian.
Thanks so much, Joanne, and thanks to the Federalist Society for hosting this interesting conversation. I'll just start by trying to sort of set the table by describing our case and how we got where we are today. So Alpine is a small broker-dealer. It specializes in the micro-cap industry. So we're talking about companies that have issued securities that are, very, very small companies. And that is a particular area of securities regulation that has been sort of a target of FINRA enforcement folks for a number of years now. Alpine has found itself sort of on the wrong side of a series of enforcement actions by FINRA over the years, mostly unsuccessful enforcement actions. There was one occasion where a few years ago, Alpine was briefly shut down by a FINRA enforcement order, only to have the Securities and Exchange Commission, which reviews FINRA enforcement activity, overturn that shutdown order. Recognizing that it was on the wrong side of FINRA enforcement folks, Alpine filed a lawsuit in the Middle District of Florida, basically challenging FINRA as unconstitutionally structured. That case was then transferred up to the Federal District Court for the District of Columbia. At that point is when I got involved in the case. While the case was in front of the district court, FINRA initiated a new enforcement action that sought to basically immediately expel Alpine from the securities industry. So for those who aren't so familiar with FINRA and its role in the securities regulatory regime, for most broker-dealers, the vast majority of broker-dealers, it's necessary to be a member of FINRA in order to operate as a broker-dealer consistent with federal law. And so Alpine found itself in this situation where it was on the verge of being essentially put out of business by FINRA, its latest enforcement action. We moved for a preliminary injunction, basically saying that the way FINRA is structured as a putatively private entity that has authority to enforce federal law violated both the appointments clause as well as the private non-delegation doctrine. We lost in the district court, took an emergency appeal up to the District of Columbia Circuit Court, and there in the DC Circuit, we got an injunction against the enforcement action back last summer, pending the appeal. And then here, about a week and a half ago, we got the panel decision, which basically, by a vote of 2-1, the majority in the panel, Judge Millett, writing for herself, and Chief Judge Srinivasan, said that the structure of FINRA, in particular FINRA's ability to expel broker-dealers from the securities industry without having any kind of, in the first instance, review from the SEC of that expulsion decision, violates the private non-delegation doctrine. The majority did not reach our appointments clause argument, when the thrust of that argument is basically that the FINRA folks, they have authority under our federal regulatory regime for securities to enforce the securities laws. And that's, significant executive authority, no different from the enforcement authority fundamentally that the Securities and Exchange Commission itself has. And so we basically said, well, these people, they're exercising the powers of officers of the United States. And so they've got to be appointed and removable the same as any other officer of the United States. The majority didn't reach that issue. There's a separate concurring opinion by Judge Walker, where he says, well, I agree with the majority. I think he calls it a victory for the Constitution, that going forward, Alpine can't be expelled from the industry without the SEC first basically conducting a plenary review of FINRA's decision to impose sanctions on Alpine. But Judge Walker would have gone even further and basically said FINRA can't move forward with its enforcement activities at all against Alpine because the way this entity is structured offends the appointments clause, or offends the private non-delegation doctrine, because we've basically given this significant executive authority to a group of people who are not appointed in conformity with the process that our Constitution has for how we decide who gets to exercise significant executive authority. And so the upshot of all of this is the DC Circuit's opinion. It didn't give anybody 100% of what they wanted. We were looking to see the FINRA enforcement actions against Alpine stopped entirely. FINRA obviously was trying to defend what it was doing and arguing that it was entitled to kick Alpine out of the industry before the SEC reviewed anything that FINRA did against Alpine. So in some ways, this is sort of a middle path between what the two sides were arguing for. And it'll be interesting to see where the case goes from here, given that neither side got all of what they wanted out of this panel. So with that, maybe I'll hit the pause button and let Hardy make some observations.
Yeah, actually, before I jump in on observations about the Alpine case, Brian, I know you've been involved in, there are a couple of other pretty important non-delegation cases that are out there. And indeed, Friday, a week ago, the Supreme Court granted cert in one of them, the Consumers Research v. FCC case. And so this non-delegation issue, private non-delegation issue is circulating in a number of cases. There's going to be, for sure by June of this year, a Supreme Court decision on non-delegation. Do you want to talk for just a minute about some of the other non-delegation cases that are out there?
Sure. Yeah, and yeah, that's an important point, Hardy, that we're going to see a decision on the non-delegation doctrine in some form out of the Supreme Court this term. The other case to highlight, or really a series of cases, is there's a series of constitutional challenges to this horse racing commission that Congress set up, really modeled on FINRA, the structure of the horse racing commission and its relationship to horse racing regulation is very similar to FINRA in that you've got there, it's the Federal Trade Commission as opposed to the SEC that has kind of a limited supervisory role that oversees what is putatively a private organization that's charged under federal law with essentially making rules and enforcing them, legally binding federal rules that are being created by this private organization. There's a circuit split about the constitutionality of that arrangement. The Fifth Circuit has held, I think, largely consistent with, what we saw from the DC Circuit as to FINRA. The Fifth Circuit has held that this arrangement offends the private non-delegation doctrine, and the Solicitor General is petitioning for cert from that Fifth Circuit decision. And so there's a whole, sort of series of these. The private non-delegation doctrine is sort of having a moment. And one thing worth, I think, highlighting from the DC Circuit case the DC Circuit opinion in our case is Judge Walker's concurring, dissenting opinion, however you want to characterize it. He tries to really kind of reconcile these two different bodies of law. On the one hand, the private non-delegation doctrine, which the Supreme Court has said very little about, broadly requires some degree of supervision when private entities have a role in making or enforcing federal law, versus, on the other hand, the separate body of law about the appointments clause, and when people within the government are vested with significant executive authority, how are those people selected and entrusted with that authority? And Judge Walker makes this move of saying, well, anytime somebody's outside of the federal government, if they're given what amounts to significant executive authority that would require them to be an officer of the United States if they were within the government, that's just per se unconstitutional. Like, you can't, under the private non-delegation doctrine, you can't give that kind of authority to a private entity. And we'll see if that idea, that concept, has legs in the case law going forward. But it's sort of I think something of an innovation. And if you read all of these opinions in these various cases, and we'll see if that concept ultimately has purchase in either of these Supreme Court opinions that we'll see.
Yeah, and I'll just observe that the other Fifth Circuit case, the FCC case about consumers research, is a sort of different strand of the non-delegation doctrine. There is a strand of the non-delegation doctrine that involves whether there's an intelligible principle for agencies to follow, and there's also an issue there about whether that principle can then be delegated to a putatively private organization. In that case, it's something called the Universal Services Administrative Company, which essentially charges a fee or a tax. Debate in the opinion about whether it's properly characterized as a fee or a tax. But that then goes to fund rural broadband and urban broadband for low-income recipients. Anyway, that's the case that the Supreme Court has granted cert on. But in that case, the Universal Services Administrative Company doesn't have the same kind of enforcement authority that both FINRA and the Horse Racing Integrity and Safety Authority does. And so I agree that circuit split in the about the FTC and the Horse Racing Authority is actually more similar to your case involving Alpine and FINRA here. But I think the point is that probably both of them will end up in the Supreme Court. One of them already has, and the other one is, I think, pretty likely to, given that the Solicitor General has requested cert on it. Anyway, there are a lot of open questions that the DC Circuit opinion leaves open in the Alpine case. It's relatively rare that FINRA summarily expels a member firm, but FINRA expels individual reps from the securities industry with a much greater frequency. I understand it's at least 50 to 100 times a year. Some of those are cases where the rep just defaults and doesn't fight, but there's an open question about whether having to pause and wait for SEC review would apply to individuals. The majority doesn't reach that. The majority in Alpine says, well, individuals can go get another job. Well, maybe so. Starbucks may be hiring, but if you can't work in your chosen field, that's a fairly significant infringement of your when other circumstances would be considered your right. So I think that's an open question whether the FINRA need to have SEC review before its decisions can become effective, whether that'll apply to individuals. Another open question is, does it just apply to FINRA or does it apply to securities exchanges? So again, the majority opinion in the DC Circuit spends a lot of time talking about industry self-regulation going back to the 1790s, most of which was done by all of which was done by securities exchanges until the Maloney Act passed in Congress in the late 1930s and caused the creation of NASD, the predecessor of FINRA. Now, there's definitely an argument that FINRA is different in that broker-dealers are required to be members of FINRA. There used to be an exception for broker-dealers that just trade on a single exchange. Actually, the SEC removed that exception earlier this year. So now I think all broker-dealers are required to be FINRA members. Anyway, does it apply to disciplinary decisions by the exchanges? And I will say that some of the exchanges actually are still quite active in bringing their own disciplinary proceedings, both against member firms and against registered people at those firms. So as Brian suggested, there's still a significant open issue about the appointments clause. So we have had the Supreme Court hold that in the case of the PCAOB and the SEC's own ALJs, okay, they have to be properly appointed and properly removable under the appointments clause. The majority in the Alpine case didn't reach that issue, said that it didn't have to reach that issue on a preliminary injunction because given the fact that the SEC was going to review the FINRA opinion, there was not irreparable harm to Alpine. The concurring judge, Judge Walker, found that was flatly inconsistent with the Supreme Court decision just a year or two ago in Axon, the FTC, which also involved the SEC. There was the named plaintiff is Axon, but there was a SEC case that was decided in parallel to that. So that's a big issue because that, when it's ultimately decided, will have a much broader effect on the overall enforcement program of FINRA. And then there's another sort of related question, which is, what, if anything, will Congress do about this? So as Brian said earlier in the case of the horse racing authority that the FTC oversees, it was initially created pursuant to an act of Congress. It got thrown out in the courts of appeal, and Congress actually went and reworked the statute to give the FTC more authority over the horse racing authority. And so that could happen with Congress and FINRA here. The PCAOB, which is another self-regulatory organization overseen by the SEC, it lost a challenge in the Supreme Court. But they have gone back and effectively fixed that, and the PCAOB is still bringing investigations against people in the the public accounting industry to this day. So there could be a fix to these issues, but that would depend on there being a consensus in a new Congress that was a desirable thing to do, and it's unclear whether that will happen or not. The Project 2025 suggested the abolition of FINRA and the PCAOB, but then I mean both of those organizations have functions that are significant functions, and I think there's an open question whether you would actually want the SEC to take on those functions and have to increase presumably its staffing and its budget, so anyway, there's just a lot of questions that remain to be addressed after this decision.
So Hardy, since you're most familiar with it, maybe for people who are less familiar with FINRA, do you want to just talk a little bit about the scope of its reach and its size and how significant, I guess, it is to people in the industry?
Sure. So just to give you a sense of scale, and I looked at these numbers over the weekend. The SEC right now has about 5,000 employees and a budget of about $2.2 billion. FINRA has about 4,300 employees and a budget of not quite $1.5 billion. So FINRA is not as big as the SEC, but it approaches that size. And FINRA does a lot of functions which, because FINRA is doing them, the SEC doesn't have to. So when you start a new broker-dealer or you want to change the membership agreement of a new broker-dealer, you go to FINRA and you have an application process. Reps have their exams, for the different licenses in the broker-dealer industry. That's all administered by FINRA. FINRA does examinations of broker-dealers, and every broker-dealer of any real size gets examined every year or two by FINRA. A few small ones go for 4 years. By contrast, investment advisors, which are registered and examined only by the SEC, the SEC moved most of its exam program to the investment advisor side on reliance on the fact that FINRA was examining broker-dealers, but still the SEC is only able to get into investment advisors. On average, they examine about 15% of their investment advisors every year, which is to say a typical investment advisor goes 7 or 8 years without being examined. FINRA also, and again, this is something that's a statutorily required process. All mutual funds have to submit their advertising materials to FINRA to get approved. So anyway, these are functions that if FINRA wasn't able to carry them out, they would have to move to the SEC. And as I say, the SEC, very clearly doesn't have the staff or the resources to do that. So again, the question I think will be if the appointments clause challenge to FINRA is ultimately successful, what's going to happen to those functions, and will Congress decide, as it has in the case of the PCAOB, okay, we still want these to be done by an agency, that is under more thorough review by the SEC. And I will say, the SEC does examine FINRA, does multiple exams a year at FINRA. All FINRA rules have to be approved by the SEC. All FINRA disciplinary proceedings that are contested can be appealed to the SEC. So it's not that there's no SEC oversight of FINRA. There's actually quite a lot of SEC oversight of FINRA, but the SEC does not approve FINRA's budget in the way that it approves the PCAOB budget. It doesn't appoint FINRA board members or FINRA ALJs in the way that it has control now at the PCAOB over PCAOB's board and ALJs.
So Brian, there was a tremendous amount of amicus for what is essentially a preliminary injunction. I was kind of surprised that the court did not seem to take up the argument being made by the various self-regulatory organizations, the exchanges and whatever, about the disruption that would cause. Do you think that was the reason they wrote so narrowly?
I could only speculate about why they wrote as narrowly as they did. It is true that there were a number of amicus briefs on the other side that sort of threatened, doom and gloom in the event that we were successful in this lawsuit. I guess two things I'd note about that. One, Hardy's no doubt correct that there's a question out there about, whether the same type of analysis extends to the exchanges. But one big difference between FINRA and most other SROs is it's illegal under federal law to practice in this industry if you're not a member of FINRA. You don't have to trade on a particular exchange to be a broker-dealer, but you got to be a member of FINRA. And that's a result. The other side likes to point to, the ancient origins of self-regulation, but when did this start, that you had to be a member of FINRA or its predecessor to be a broker-dealer? The answer is 1983. There was a long period when somebody could operate as a broker-dealer consistent with federal law, and membership in an SRO was optional. And that changed in 1983. And so that's like a really big difference between this particular regulatory regime and a lot of the other ones that involve SROs. The other thing I'd say is, we've been down this road in lots of separation of powers cases at this point. You think about what the Supreme Court did to SEC ALJs and Lucia. You think about the PCAOB case, Free Enterprise Fund. You think about the CFPB case, Saylor Law, or the FHFA case, Collins against Yellen. All of these are cases where the Supreme Court found that there was some separation of powers problem or appointments clause problem with the leadership structure of various organs of government. And, the wheels didn't come off. We didn't stop regulating the accounting industry after Free Enterprise Fund, right? We just changed the way the leadership at the PCAOB is selected. We recognized that the president would have the authority to remove those people without the insulation of a double for-cause removal protection that Congress had written into the statute, and we moved forward, right? And so, at this point, there have been enough of these successful separation of powers challenges where, you pick up the pieces, you restructure the leadership structure, and you move forward. That I don't think it's so plausible to think that, the whole financial system is going to come crashing down around our heads if we restructure FINRA's leadership structure in a way that comports with what the separation of powers requires.
Yeah, and it's a really good point. I mean, FINRA points to cases going back to the I think late 50s and certainly in the 60s, upholding the SRO regulatory structure against various kinds of constitutional challenges. And those decisions have continued since then in a number of courts of appeal. None of those cases, though, really grappled with the change in 1983. So until 1983, there was something called SECO, the SEC only broker-dealers who were regulated only by the SEC and were not a member of either the NASD or a securities exchange. And the fact is, the SEC didn't like having to run the SECO program and didn't think it was efficient. convinced Congress to change the law and require, at that time, all broker-dealers who had members of the public who were customers to become NASD members, now FINRA members. And as I say, the last refuge of non-FINRA members was proprietary trading firms on exchanges that were only trading their own, as I say, proprietary money. And the SEC changed the rule on that in the last year to say they needed to become FINRA members as well. So about a little over 50 firms had to join FINRA as a result of that. So one of the questions I see that we have in the chat is, well, is FINRA a state actor or not? And that's a really interesting question, which the court doesn't actually quite decide. And there's a way of looking at this, which is that, there's the private non-delegation doctrine. If FINRA is private, then it can't do certain things, but if it's really public, then the appointment clause applies to it. I mean, this is an issue that has been bouncing around for years. There was a guy out here in California, a well-known investment banker, Frank Quattrone, who made that argument and took it to the SEC back in the after the sort of the .com crash, and the SEC dodged the issue and said in that case FINRA and the SEC had coordinated, and so in that case there was an argument that FINRA was acting as a state actor. But generally speaking, FINRA has taken the position that it is not a state actor, but at the same time it gets state action immunity for its rules, because its rules are approved by the SEC, and there's certainly been an argument in the securities industry that and that's true for the exchanges as well. Their rules also get state action immunity under the antitrust laws. So that things like the FINRA 5% markup guideline, that would be an antitrust violation, but for the fact that that FINRA has state action immunity for its rules that are approved by the SEC. So I do think that as the Supreme Court thinks about these issues, we're going to get some more clarity about where the line is between a state actor and a private actor. But I mean, there are these different doctrines, this private non-delegation doctrine and this appointment clause doctrine that, one or the other applies depending on whether it's a state actor or not.
Yeah, and just to supplement that, one way that we kind of think about this issue, the private versus public issue, is at the end of the day, FINRA has government power. They make rules that carry the force of federal law, and they can enforce those rules. And if they bring an enforcement action against you that's successful, the result of that can be it is illegal under federal law for you to continue to operate as a broker-dealer. Right. And so it's maybe an interesting question under like the state action doctrine of, well, is FINRA, a state actor or not? But it's definitely got government power. Right. And I think that's kind of the starting premise of really both the majority and the partial concurrence, partial dissent, is like, these guys are exercising power that's been conferred on them by federal law. And that's a really important analytical move, because, as Hardy said, the threshold defense that FINRA has raised, largely successfully before this decision, has been, we're just a private club. It's no different from, the country club saying you've got to wear a necktie if you want to come in and have lunch, and we'll kick you out if you don't have a necktie on. We're just enforcing our private club's voluntarily chosen rules. And that defense did not work with any of the three judges on this DC Circuit panel. And once you set aside that kind of frontline defense that has been kind of FINRA's go-to defense across all of these cases for all of these decades, as Hardy said, there are a lot of big questions about, well, how far does this go? What is the scope of FINRA's obligations to comply with the Constitution? There's a question around, jarcossy and the Seventh Amendment. Does when FINRA brings an enforcement action and imposes a monetary penalty on someone, is there a jury trial right there? And we didn't raise that Seventh Amendment argument as part of our appeal of the preliminary injunction, but we do have a Seventh Amendment claim in our case, and I know there are other people who are suing FINRA on a similar theory in the wake of jarcossy. And there are questions around the self-incrimination clause. The Fifth Amendment generally doesn't permit government officials to force people to give testimony against themselves that may implicate them in crimes. And FINRA does that when as part of its investigatory process. And is there a Fifth Amendment problem here? So there are a lot of big questions that you got to answer once you kind of cross the threshold of recognizing, these guys have federal power, and the Constitution is implicated when somebody exercises federal power.
Yeah, I'll just observe in the horse racing case in the Fifth Circuit, the FTC case, the Fifth Circuit there said that the process of doing investigations, opening investigations and investigating people, that's a governmental kind of authority, and it has to be done by somebody who's properly appointed to do that. And the point is, both at FINRA and with most other similar kinds of SROs, the vast majority of these enforcement investigations, if the staff decides to go forward, they settle, because people in the industry are very reluctant to litigate against one of their primary regulators. So bringing that into the sort of scope of government control really does make a big difference. I'll just observe that issue about self-incrimination. I mean, that was the issue in the Quattrone case, that, as I say, the SEC kind of dodged that issue, and the case went away on a sort of very fact-specific basis. But another area I'd bring up is advertising regulation. FINRA takes the position that because it's not part of the government, the First Amendment doesn't really apply to its review of advertising regulation. And I work with the FINRA ad reg people a lot, and I think generally speaking, they can be reasonable. But I mean, they enforce rules that would be very hard to defend at the current Supreme Court in terms, if they were subject to First Amendment review. So anyway, a lot does turn, in my view, on this state actor determination, and as I say, I think the November decision in Alpine and the DC Circuit doesn't fully resolve that, but it is something that I think we're going to get more clarity on over the course of the next year, in the Supreme Court.
So Brian, one of the questions is whether or not if FINRA were to settle with Alpine, they could render this case moot. I mean, knowing FINRA, I suspect there's not going to be a settlement, but I could also see a motivation there. So what do you think happens next? Because I've seen some speculation in conservative legal blogs that there'll be a request for rehearing en banc, or a try to take it directly to cert, or what. So I'm curious what your thoughts might be in terms of gaming out the next steps in this case.
Yeah, it's one of the hard things about this gaming it out is neither side got all of what it wanted out of the panel decision. So, I think theoretically either side could potentially seek either en banc rehearing or petition for cert. Certainly, as Hardy mentioned a few minutes ago, there are a couple of other cases that may be a little farther down the pipeline at the Supreme Court than this one in terms of teeing up issues around the private non-delegation doctrine, albeit not issues specific to FINRA. I'm not in a position to say one way or the other exactly what Alpine's plans may or may not be in terms of whether we'll be seeking additional appellate review of this PI ruling or not. But yeah, it's definitely one that people should stay tuned, because I think both sides potentially could
Because
have the
the
ability to
district
do that.
court was hard fought too, right? There were lots of motions made.
Yeah, that's right. It was on a very expedited clock in the district court, and although the district court ruled against us, I have to give the judge there credit for moving with a lot of speed, which is what we needed, because Alpine was literally, potentially days away from being shut down as a result of this expedited FINRA enforcement proceeding. And we got, to the district judge's credit, we got a ruling against us very, very quickly that made it possible for us to get up to the DC Circuit and seek further review of that before Alpine was irreparably harmed. Hardy mentioned this irreparable injury issue, which is kind of the way that the panel majority, they ruled against us on irreparable harm, saying basically it's not an irreparable injury to be subjected to an enforcement proceeding at the hands of someone who is allegedly operating in violation of the separation of powers. And on that issue, one thing I just highlight is there's some backing and forthing between the majority and the partial dissent in our case about that irreparable harm issue. And some of it turns on disagreement around an earlier DC Circuit case called John Doe Co. versus the CFPB. And that's an interesting case because that was another 2-1 ruling in I think a preliminary injunction posture. And the dissent in that case was written by then Judge Kavanaugh, basically taking the same position that Judge Walker does, and saying, no, it's an irreparable injury per se to be subjected to an unconstitutional proceeding at the hands of a regulator that's structured in a way that offends the separation of powers. And so that's an issue where we have at least one Supreme Court justice who I think would take Alpine's side of that, in addition to the Axon case from a couple of terms ago that has some language that seems to point in our direction as well.
Yeah, and obviously I don't have any particular insight into what FINRA may or may not do, but this isn't a set of issues that has popped up as Brian has said, in other cases as well. And my guess would be that FINRA actually has an incentive to get an answer one way or the other, rather than have to sort of fight preliminary injunctions, in federal court when, whenever they bring their own enforcement proceedings. So while, as I say, it's always possible that a case could settle out at some point. My guess is that FINRA actually does want to have an answer to these questions, and so for what that's worth, I would think that they actually may have incentives towards litigating it, so that if they do have to go to Congress, they and the SEC have to go to Congress, they know the answer to that, as opposed to having uncertainty over a large set of proceedings for a long period of time.
So one of the themes in some of the cases that have challenged the SEC has been how long they take to resolve enforcement proceedings. And Hart, I don't know if you have a view, but if the SEC is required to review expulsions, not just of member firms, but of registered reps, that's a resource challenge also.
Well, it is, and in fact, some of the longest delays have actually been at the SEC on appeals from FINRA and the other SROs. So, doing the SEC's appellate function has not been a super high priority for SEC commissioners over the years. Certainly not in the last 4 years. So. There are a lot of things that come to the SEC commissioners to decide. Their rulemaking agenda, all of their own enforcement cases, and historically finding time to decide those SRO appeals. Reading the records in those cases. It just hasn't been something the SEC has has wanted to do. So there definitely is an issue there, and the SEC may have to think about, whether there is any way they can try to streamline that. Just one thing I thought I should mention here, we talked a little bit before we were live about this, is this structure. I mean, we've talked about the FTC and the FCC, but it's a very common structure throughout the federal government. Certainly on the CFTC side, the NFA has a role that is almost identical to FINRA's role in the securities side. Every commodities, futures commission merchant and introducing broker and commodity pool operator and commodity trading advisor, they're all required to be members of the NFA, the SRO on the CFTC side. And so, that is very similar. I think this structure from the Maloney Act that, originally created the NASD, has been something that Congress has used in a lot of different administrative agencies, and all of them are a little bit different. And, the Fifth Circuit decision in the horse racing case, distinguished FINRA because it said it was a little bit different from FINRA. But the implications here are not just in the securities industry; they really are across a lot of the federal government.
Yeah, I certainly agree with that there are potential implications, beyond FINRA. I think the NFA is, super similar to FINRA. I guess one point I would make here is I think once you get past FINRA and the NFA, it's a little bit unusual to see one of these SROs where, number one, it's mandatory membership. You've got to be a member of the organization in order to, practice in the trade. And then number two, the entity's got enforcement authority. So it's not, some federal official who's being given a tip by the private organization and makes the decision about whether to bring an enforcement action. No, it's, the putatively private organization itself is the one that's sort of exercising the prosecutorial discretion. Because I think, one of the sources of the strength in our argument has been, look, this is just like a prosecutor, deciding whether to go after someone. And, that's the quintessential executive function, deciding when to bring an enforcement action against someone. So how could this possibly not be an exercise of government power that's got to, comport with the Constitution?
What implications on this, if you've thought about it, Brian, on the state level? I think of a number of particularly professional organizations that are mandatory, like I'm a member of the California Bar because I have to be to practice. So are there implications here, or is that a question of state constitution?
Yeah, there are some implications. That's actually a question the district court put to me at our preliminary injunction hearing. And the point I made there was, yeah, if you think about an integrated bar, there's, where you have to be a member of the bar to practice law in the state. There's a lot of case law to the effect that before the Integrated Bar Association kicks you out of their putatively private club, you've got to get the protections of due process, right? The government can't strip you of your professional license, your ability to practice law, without giving you due process. And, that holds true even in states with integrated bars. And so the idea that the Constitution in this type of situation would come in and, put some constraints on the ability of, somebody to exercise government power, I think is not at all unusual or troubling. One thing I would say is, many of the arguments that, we are making against FINRA with respect to the separation of powers, the appointments clause, the civil jury trial right, these are not federal constitutional obligations that are imposed on the states. And so, if a state wants to have, some private organization that's akin to FINRA, that organization might have to comply with due process. It can't discriminate on the basis of race, whatever, but it wouldn't necessarily, have to have its leadership selected in a particular way. That would be a question of state constitutional law.
Yeah, I mean, to me, this comes down to the state actor issue. If like an integrated state bar, because it's exercising government power, it has become a state actor, then it's subject to, federal constitutional limitations that apply to the states. So like the First Amendment, I mean, this is why we now have lawyer advertising, which we didn't at one point have, is because, states are subject to the First Amendment. They can't restrict advertising. But as Brian says, the law has been historically that the Seventh Amendment is just a federal right to a jury trial. It doesn't apply to the states. Under the current Supreme Court, could they revisit that issue? Sure, they could. As the podcast people say, stare decisis is for suckers. But historically, that has not been an issue that constrains the states. And similarly, as Brian says, the appointments clause issue is a sort of uniquely federal issue. And while you could certainly imagine some states interpreting their state constitutions to have similar requirements, that isn't a U.S. Supreme Court issue. It would have to be a state Supreme Court issue. Joanne, you're on mute, I think.
Do you see any changes in approach as a result of the change in administration?
I think it is a very interesting question whether the incoming administration will agree with the Department of Justice's existing position in this case. So the United States intervened in our case to take FINRA's side of this. And I will just note that there is an OLC opinion from the George W. Bush administration that it deals with who is and is not subject to the appointments clause. And there is a section of analysis in that opinion that pretty strongly points in our favor. Now, the Department of Justice has sort of done backflips to try to explain why its current position in our case is consistent with that OLC opinion. FINRA's counsel, to his credit at the DC Circuit argument, just flatly conceded that the position he was arguing for was not consistent with that old OLC opinion. And so, will the incoming administration revisit this? Will they, agree with the position that, a past Republican OLC took on sort of related issues about when the appointments clause does and doesn't apply? I don't know, but I'm certainly hopeful that, the incoming administration will take another look at this.
Yeah, at the SEC itself, I mean, historically, I think the SEC, through different administrations, Republican and Democratic administrations, has supported the autonomy of the SROs, and that's been consistent. That hasn't been something that has changed. We could, I mean, obviously, we don't know who the new SEC chair is going to be, and we could have a different approach, but I would certainly think from an institutional perspective, as I say, I think the SEC would be very reluctant to have to take on some of the tasks that FINRA currently engages in, and so I think there may be an institutional reluctance as well to flip from the historic position of the SEC, which is that the SROs are not state actors and are entitled to proceed essentially as they have been.
And it's worth highlighting here, I think, the fact, we're in this moment of a transition between control of the executive branch by one party to another. And, what's going to happen at the SEC? Within the first week or so of the Trump administration, there'll be a new chair of the SEC who will, take the commission in a different direction based on, the outcome of that election. Well, what's going to happen at FINRA? No change, right? And that's kind of the whole problem that we're pointing to with these appointments clause and private non-delegation challenges is, it doesn't make sense. If somebody thinks that FINRA is too inflexible, their enforcement priorities are out of whack, they go too hard on the little guy and give the big guy a pass, whatever, series of criticisms somebody might mount against FINRA, we have elections in this country. And, when people vote in a new president, the enforcement priorities in the executive branch ought to reflect, the outcome of the election. And we don't get that with FINRA because of the way its leadership is structured.
So there are a bunch of questions in the comments. I mean, one actually, I think, Brian, would be worth you explaining, which is who's defending FINRA? Is it?
Yeah, that is an interesting question.
I mean, the DOJ and SEC are both in the case, but they're not actually representing FINRA.
Correct. Yeah, FINRA is represented by Gibson, Dunn and Crutcher, which interestingly is the same law firm that's brought private non-delegation challenges to the Horse Racing Commission. So they're sort of making arguments in the Supreme Court that sound a lot like the ones I'm making in the DC Circuit right now. But yeah, it's very, very capable lawyers at Gibson who are defending FINRA.
Oh. And another question I see is, what about a challenger SRO being formed? And that is an idea that people have come up with from time to time. And to do that, you would have to have that SRO be approved by the SEC, and it would have to go through a very lengthy application process. The SEC does approve new securities exchanges, just approved a new sort of 24-hour-a-day securities exchange in the last week or two. But this was a while ago, but certainly when I was at the SEC back in the 90s, the internal lore was there would never be another national securities association. That one was enough. That's what the SEC was comfortable with. Again, could that change in a new SEC? It could, but no one has ever gotten anywhere with that kind of a proposal, and I wouldn't bet a lot of chips on that particular approach. Well, Joanne, do you have any last words for us? I think you're still on mute.
I was just doing a quick scroll through the questions to see whether we've addressed most of them. I think we have. So I wanted to thank everybody for attending and for some really good questions there in the chat. So Edie, over to you.
Yeah, thank you so much. On behalf of the Federalist Society, we thank Brian and Hardy for speaking with us today and Joanne for moderating. We're very grateful for your time and expertise. And thank you also to our audience for joining us. We greatly appreciate your participation. You can stay up to date with announcements and upcoming webinars on our website, fedsoc.org, or on all major social media platforms. Thank you once more for tuning in, and we are adjourned.